Hello, I'm Paul Smith. I'm a solicitor and risk management consultant at Travellers. In this video podcast, I'll be looking at a number of different dishonesty situations in legal transactions. By the end of this video, you will know how different dishonesty risks can arise and what you can do to control them. By way of background, I have been working in risk management consultancy at Travellers since 2010. Before that, I spent almost 20 years dealing with professional indemnity claims against solicitors. As you'll hear shortly, we see relatively few dishonesty claims, but they are, on average, more expensive to resolve. Along with the obvious settlement costs to insureds and insurers, they can also result in time-consuming regulatory and criminal investigations, foster a climate of suspicion, undermine reputations, and potentially compromise a firm's future.
We'll start with a brief explanation of risk, or a reminder if you've seen some of our other briefings. Risk is about uncertainty, in particular the impact of uncertainty on objectives. A key objective of any legal service provider is the delivery of a legal service safely, so protecting the interests of the client, the firm, those in the firm providing the service. Achieving this objective requires management of the day-to-day or operational risks, like dishonesty, that firms face when providing a service. Dishonesty risks can arise in several ways, and in recent years many of these have been facilitated by the increasing use of technology. The dishonest client, for example, engaging in identity theft. This is often facilitated by providing instructions remotely, being elusive, and using fake ID. A direct attack on client account. This can be by someone within the firm, say through fraudulent accounting. Alternatively, it can be carried out by criminals operating externally. One example is social engineering in Friday afternoon fraud. A criminal masquerades as an employee of the insured's bank, claims that the account is under attack, and that they need to access it to stop monies being stolen. This approach can persuade someone in the firm to pass over the codes which give the criminal access to the account. Next, third parties. These are often criminals who hack IT systems by cracking passwords or using phishing emails. These contain innocent-looking links which, when clicked, install malware, which can be used to access information on a firm's systems. A variation of this is ransomware. This enables the criminals to extort money or information by taking over a target firm's IT system and restoring access to the firm for a fee. Criminals also use spoofing emails, breaking into email chains and passing themselves off as a party to a matter, or as someone in authority who can authorize payments by the firm, so-called whale fraud. They can then divert funds to accounts which look legitimate but are in fact under the criminal's control. Investment, where funds invested by the firm or handed over to third parties to invest are stolen. And mortgage fraud, in property transactions, where criminals set out to defraud lenders. Over the past 6 years, dishonesty claims have accounted for 3% of notifications, but for 12% of all payments made by us and by our insureds in the form of settlement monies and excesses. And some work areas are particularly susceptible to dishonesty risk. First, residential property and lending. This accounts for almost 50% of the dishonesty notifications we've received over the last 6 years. There are dishonesty risks throughout residential property and lending work. Here are the main stages in a transaction where those risks arise. Searches and inquiries, inadequate due diligence around conflict and AML checks, and know your client procedures. The result, a failure to spot dishonest or bogus clients. Title, a mix here of dishonest and bogus clients engaging in identity fraud, claiming ownership of property belonging to others. Ownership terms, bogus instructions from dishonest clients as to how a property will be held in future. They are effectively stealing from the true owners who are often unaware of the transaction. Exchange of contracts, with fraudulent or spoofing emails from criminals. Completion. Most cases again involve spoofing emails. We also see social engineering, designed to divert completion monies. Of the rest, the most frequent risk is internal fraud. For example, individuals stealing completion monies from client account or seeking payment for bogus services or disbursements. And completion is also a time when we see dishonesty around lending. There are a mix of issues here. Sometimes dishonesty can be simple corner cutting, like completing attestation clauses in loan documents after the event. Alternatively, clients claim to act for both husband and wife without instructions for one or other of them, or there are discrepancies between the surveyor's valuation and the consideration appearing in the transfer. The next most frequent area for dishonesty notifications is trust and probate work. There are two main areas for claims in this work. First, distribution, the loss of estate assets through internal fraud, billing for work not done, or employees simply stealing estate funds from client account. Spoofing attacks by criminals to access estate funds held in client account. And theft of chattels from the deceased property left unsecured by executors or administrators. Next, court of protection work. The main issue here is deputies breaching their duties and forfeiting their bonds. As legal work usually involves holding a client's money or confidential information, dishonesty issues crop up in other work as well. In commercial litigation, we have cases of theft of funds from client account by a partner or an employee. We sometimes see allegations of dishonesty where firms act in matters where allegations of dishonesty are the basis of the main claim. In commercial property and lending, the issues here include due diligence and client identity, spoof emails and the diversion of funds, forged signatures on documents, and transactions allegedly at an undervalue wherein a client goes into liquidation. Also company and commercial work. Some examples here. Firms acting in transactions where corporate funds were used for a director's personal benefit, in one case in the purchase of a residential property, or allowing the firm's account to be used as a banking facility by a fraudster when there was no underlying transaction. We also have dishonesty notifications and claims where there is no retainer. These cases most often involve attacks on client account through social engineering or internal fraud by partners or employees, sometimes through simply allowing the client account to be used as a banking facility, and the actions of third parties, criminals cracking passwords and using phishing emails to hack IT systems and install malware. So what drives dishonesty risk? Operational risks, like dishonesty, have four main causes or sources. People, so clients, owners and managers of the business, frontline staff, outsourced suppliers. Product, the way you organize your work and manage the delivery of your service to meet your client's objectives. Process, the firm's infrastructure, which supports people and the delivery of the product. And risk maturity, a measure of the quality of risk management within an organization. We'll look at these in more detail, starting with risk maturity. Low risk maturity, or risk immaturity, means a lack of awareness of the need to manage risk and/or the capability to do so. This can be down to failures in leadership, so a lack of clear messages from the top on the importance of risk management, ownership, individuals not taking responsibility for managing risk, or a lack of accountability, not taking responsibility for the consequence of risk management lapses, plus learning, the building up of knowledge of risk issues, and finally limited communication and feedback. This can be around risk issues generally, or more particularly about the firm's own claims or near misses. One, some or all of these issues together can mean a lack of awareness of the scale or source of dishonesty threats, so reduced understanding of the need for controls or reduced motivation to follow systems and processes to prevent fraud and crime, the development of blame cultures, a lack of curiosity about why a claim occurred, a failure to learn from the past, which leaves firms open to repeat claims. Next, process and the risk causes here. These are the systems which support the delivery of the product. Dishonesty risk sources here include a simple lack of process or systems, or processes being ignored, not followed or defective, resulting in insecure assets, with money or data being left unprotected. One, some or all of these issues together can increase the risks around people by tempting people to be dishonest. They can be genuine or bogus clients, criminals, individuals within the firm, or outsourced service suppliers. This risk can be heightened by disengaged staff and risk immaturity. Finally, product. This is about dishonesty risk in the course of the retainer. Some of the product issues we see include a failure to identify clients or clarify instructions, a lack of a formal retainer or incomplete retainer documentation. This means an opportunity lost to understand the nature of the matter and spot evidence of fraud, making assumptions or turning a blind eye to anomalies, using insecure methods of communication, and frequent or complex amendments to instructions, leading to confusion and potentially allowing fraudsters to cover their tracks. So some examples of how dishonesty risk presents and what causes it. Now for some controls, starting with risk maturity. The focus here is on raising risk maturity by raising and maintaining risk awareness. This means clear messages from management about the importance of and need for risk management. Everyone having a clear role to play in managing risk. The message here is that everyone within the firm is a risk manager. Providing opportunities for learning, whether formal or informal. Everyone being accountable for risk outcomes. And communication about risk, both in terms of general trends and threats, and the firm's own risk profile and experience. A key point here is the potential to use claims, notifications of circumstances, and near misses as a learning opportunity rather than an opportunity to blame. A blame culture can generate a mindset of cover up, not own up, and drive risk issues underground. The ultimate aim should be to operate a just culture, where there is a balance between accountability for an error and learning the lessons from it. Next, process. Controls here include staff screening pre-employment, having a whistleblowing policy to flag up internal fraud, protecting access to assets, for example with passwords, limiting an individual's authority. This can be through segregation of duty, where a number of individuals must act in sequence to complete a process, for example releasing funds. Alternatively, through duality, where two people are needed to carry out a step in a process. Next, training on the purpose of anti-fraud or cybercrime measures and the importance of consistent application. People risk controls. These include anti-fraud measures which are properly supervised, financial audit reconciliation processes, and file audits and feedback. Finally, product risk controls. Having structure around the delivery of the matter can help identify potential signs of fraud and dishonesty. So carry out robust due diligence, conflict checks, know your client procedures, AML, enhance due diligence where appropriate. Document the terms of the retainer, establish the factual matrix, identify and address assumptions, investigate anomalies, and structure communications to limit opportunities for spoofing and hacking. One method is a communication protocol. This sets out who communicates with whom, when, how frequently, and in what format. It could also cover how sensitive information will be communicated or the use of passwords to verify identities given the insecure nature of email traffic. For more risk management guidance, in particular the other briefing podcasts in this series, please go to the address on the screen. A final point, our disclaimer. Please take a moment to review this. As a précis, this talk is for guidance only, and there is no liability over the information supplied, which is also not exhaustive. So a précis of the précis is that terms and conditions apply. I hope you found this presentation helpful, and thank you for watching.